afternoon, everybody. The Senate Labor Committee is called to order. I will note for the record that we do have a quorum, and we are ready to proceed with our agenda today. First, we have Senate File 3725, which is brought to us by Senator Mann. Senator Mann, welcome to the Senate Labor Committee.
Thank you, Madam Chair. Remember, Senate File 3725 will require employers to post salary ranges on job postings. Members, we know that the pay gap is real. We've all heard the statistics dozens of times, so I will not repeat them. But I do want you to know that we have testifiers who will speak about these things today. I'll just mention some of the benefits. So numerous states have already done this, and data suggests that not only is the compliance quite high, but that it's working. Employers and employees are seeing benefits. So for employees, we see that there's the increased transparency leads to more informed choices, obviously, but includes better negotiating power and higher levels of trust between the two parties. We see that in positions with pay transparency, the employees report higher levels of job satisfaction, and they are 30% less likely to leave. Employers are telling us that they are saving time and money. They spend less time interviewing potential employees who drop out of consideration when their compensation expectations don't align with what is offered, and so they are saving time and resources on recruiting and hiring. They also see greater employee retention, like we talked about, and increased productivity from their employees, also thought to be secondary to that increase in trust and transparency. Most importantly, transparency in job postings produces 70% more applicants and 66% more qualified candidates. This is good, sound, proven policy, and with that, Madam Chair, I'll turn it over to my testifiers.
Thank you, Senator Mann. And I believe also you have an A1 authors amendment.
I do, Madam Chair.
Could I ask someone on our committee? Thank you. Senator Pappas moves the adoption of the A1 authors amendment. All in favor say aye. Aye. Any opposed say nay. All right, the A1 is adopted. And first on our list of testifiers, we have Professor Jill Hasday, followed by Heather Heyer, welcome to the Senate Labor Committee. If you'd please introduce yourself for the record and proceed with your testimony.
Chair McEwen and members of the Labor Committee, thank you for inviting me. My name is Jill Hasday. I'm a distinguished McKnight University professor and the Centennial Professor of Law at the University of Minnesota Law School. I teach and write about sex discrimination and constitutional law, among other subjects. I'm delighted to be here on what's actually Equal Pay Day. In my time today, I'd like to make one simple but fundamental point. Pay transparency promotes pay equity. I'll start with some historical background before describing the current state of the law and the need for legislative action. Before 1963, it was perfectly legal for employers to pay women less. This type of discrimination was pervasive and out in the open. For example, help wanted ads would list one salary for male workers and a lower salary for women performing the same work. Many Americans hoped that the Federal Equal Pay Act of 1963 would end pay discrimination between men and women, but more than 6 decades later, an enormous wage differential persists. The median annual earnings for women working full-time and year-round in 2022 were just 84% of the median annual earnings for full-time year-round male workers, with Black women earning just 69% of white men's earnings and Latinas earning just 57%. Minnesota's statistics are even worse. Over the past 5 years, women who work full-time and year-round in our state earned an average of 79 cents for every dollar a full-time year-round male worker took home. 31 states had smaller gender wage gaps than we do. One important reason for these persistent wage gaps is that employers often keep their pay decisions secret. That pay secrecy makes it easier for employers to get away with paying different salaries for the same work. How is a job applicant supposed to know that the employer is offering her a lower salary if the employer can keep the wage or wage range secret? Federal law does not require employers to disclose a job's wage or wage range. I'll repeat that because it's important. Federal law does not stop employers from concealing a job's wage or wage range. Keeping wages secret facilitates pay discrimination, but efforts to amend federal law to require employers to disclose wages or wage ranges have so far been unsuccessful. A growing number of states have responded to this problem by enacting their own legislation. An October 2023 survey found that 11 states had wage range transparency laws in place. These laws are aimed at promoting pay equity. Researchers found that a similar Canadian law requiring the public disclosure of university faculty salaries succeeded in shrinking the gender pay gap for those salaries. Minnesota should join this reform movement. Every Minnesotan deserves equal pay for equal work. Thank you for your time.
Thank you for your testimony. Next, we have Heather Heyer. Welcome to the Senate Labor Committee. If you would please introduce yourself, we look forward to your testimony.
Thank you so much, Chair McEwen, committee members. Good afternoon. For the record, my name is Heather J. Heyer, and I am the Director of the Office on the Economic Status of Women at the Minnesota Legislative Coordinating Commission. It's an honor to be before you today in support of Senate File 3725. The gender wage gap is a complex issue, but research tells us that there are three main factors that impact the wage gap. They are occupation, experience, and discrimination. This bill helps to eliminate the third factor, discrimination, because it requires employers to post a salary range before they even know who they want to hire. There is still a wage gap problem in Minnesota. Overall, the gender pay gap in Minnesota has barely moved in the last decade, and it's even worse for women of color. The Women's Foundation of Minnesota recently released their report on the 2024 status of women and girls in Minnesota, and they find that the pay gap for white women is 82 cents compared to a white man's dollar. The disaggregated data, however, shows even more stark disparities, with Somali women making 51 cents to the dollar, Hmong and Latino women making 57 cents to the dollar, Black women making 62 cents, Native American women making 64 cents, and Asian American women making 72 cents. This law alone is not going to stop discrimination or the gender wage gap, but in conjunction with other laws that we already have on the books, including wage disclosure protections and the pay history ban, Senate File 3725 would help to address and close the wage and racial pay gap that exists in Minnesota. The National Women's Law Center notes that research also suggests that public pay range transparency helps raise wages for low-paid workers, in particular, as workers learn what different employers pay and are able to use the pay information to seek out other better paying opportunities. We also know that the lowest wage earners in Minnesota tend to be women. The 2024 Status of Women and Girls finds that women make up the majority of Minnesota workers who are paid at or below minimum wage. Senate File 3725 is another important step to address the persistent gender and racial gap in Minnesota, pay gap, I should say.
Thank you for your testimony. That completes the list of testifiers that we have for the bill. Senator Mann, did you have anybody else or any final words that you'd like to share with the committee before we proceed to discussion? Okay. All right, members, I just want to move then to discussion of Senate File 3725. Are there any questions or any discussion on the bill? All right. Senator Dornick?
Thank you, Madam Chair. Thank you, Senator Mann, for bringing this forward. Thank you to testifiers that came. It's a good bill, so thank you.
Yes, Senator Kupek.
Thank you, Madam Chair, and thank you, Senator Mann. I had last year a similar bill that would not allow employers to ask the employee their previous salary wage, which also was kind of aiming at the same thing. So this kind of dovetails into that. So thanks for this.
All right, I concur. Excellent bill. Thank you very much, Senator Mann, for bringing this before our committee. And I believe that the plan is to lay this over for possible inclusion. So with that, seeing no further discussion, Senate File 3725 as amended is laid over for possible inclusion. Thank you, Senator. Next on our agenda is Senate File 4780, which is brought to us by Senator Fateh. Welcome to the Senate Labor Committee, Senator Fateh.
Thank you so much, Madam Chair. Thank you, members, for the opportunity to present Senate File 4780. Before we begin, may I move the A1 amendment, or may I have the A1 amendment be moved?
Yes, members, there is an A1 amendment for Senate File 4780. And Senator Pappas moves the adoption of the A1 amendment. All in favor, please say aye. Aye. Any opposed? The A1 amendment is adopted.
Thank you so
Senator,
much.
to your bill.
Thank you so much, Madam Chair. And the A1 amendment was just plugging in some of the rates that was agreed upon by the members, but also some data that was given to the Department of Labor. A lot of data that was collected about rate shares and driver rates. So we have it. We plugged in $1.39 per mile and 49 cents per minute, and then we added 91 cents per mile for riders that have a vehicle, like a wheelchair accessible vehicle. These are things that were discussed within the task force that was brought last year. I'm going to try to be brief. I'm not going to go too much in detail because we've had this bill also heard last year. I'll give time to other folks to speak, but we heard countless stories of folks struggling to make ends meet. They've seen their wages go down year after year, driving for Uber and Lyft. They had issues with deactivation. We had members drivers talking about how that when they have been attacked by a rider, even put in the hospital, that they came back and had their accounts deactivated, and that was wrong. The workforce group there. So last year we went through this process. We got the bill passed. It was vetoed, and there was a task force that was put together to discuss how we can best help the drivers in terms of insurance, wages, protections, all of the above. So a lot of the recommendations were put into this bill by consensus, and also through some of the members. And by the way, Uber and Lyft were also part of that task force as well. I want to just share quickly some information that I found online from Forbes magazine. One of the issues that Uber and Lyft state time and time again is they can't afford this and they'll have to leave the state, which will not, in my opinion, will not happen. In Forbes last month in February, they said that Uber now trades at by far its highest price ever, and its stock is now notably up 25%. It expects higher than forecasted earnings growth over the next 3 years, and will conduct $7 billion of share buybacks, the first stock repurchase or dividend payout to shareholders since 2019. Lyft, just as much, also saw shares rose 37%, and well above analyst estimates. So they're doing just fine. They're doing really, really well, enough to do buybacks. And I think that what we see is that this wouldn't be possible without the labor, without these drivers. These drivers are the reason why Uber and Lyft are enjoying their billions of dollars in revenue. So I'll stop it right there, and I'll pass it on to the next testifier.
Thank you, Senator. First on our list of testifiers, we have Stephen Cooper, followed by Eid Ali. If you'd please introduce yourself formally for the record, and we'll look forward to your testimony.
Thank you. My name is Stephen Cooper. I'm a labor and employment attorney, and I've been assisting the MALDA since essentially the beginning. One of the things to keep in mind is the things that are being said in this bill are happening today. The workers are making less than one half of anybody's estimate of what minimum wage is, less than one half. After you deduct the fact they pay for all the gasoline, they pay for the cars, they pay for all the repairs. In essence, as the report that the Commissioner of Labor and Industry did, they are the big capitalizers of Uber and Lyft. They are the ones that take care of making sure things happen. Uber and Lyft only contributes to software, very little else. So the drivers are here, the cars are here, the vehicles are here. A couple of things to look at is despite the fact they invest tremendous amounts of money, they can be terminated at any time right now. The deactivation allows them to be terminated at any time without any explanation or reason. And what we have very often when we've gone in and looked at it is because they're transporting people who are drunk or high or angry, they often will get false complaints against them with absolutely no basis at all. And when you go back and look at those complaints, you find they're false. I'm only highlighting a couple things, but this statute addresses most of these concerns. It addresses making the pay fair. It addresses giving drivers the right to be heard before they're terminated in an appeal process before they can be terminated. Don't forget, this is all the money most of these people have. I was listening to your last bill, and I was listening to the speaker, and she was saying that one of the things you find in the workforce is minority groups, other people like that make a lot less money. This is probably the most exploited single group. It's about 70% immigrant. It's made up often of people with limited pre-existing context, and they're completely exploited. But this is a pattern that happens with Uber and Lyft throughout the country. When you look at the bill, and I'm not going to go through it because I know you've all been through the bill several times. When you look at the bill, it very carefully addresses each of these issues. And as the senator said, it's gone through a tremendous vetting process. It went through the vetting process of being in the legislature last year. It went through the vetting process of the committee that was chaired by the two commissioners. And then since it was done, it went through a lengthy vetting process between the other elected officials. What comes to you is a bill of tremendous compromise and tremendous thought. I urge you to pass it. Thank you.
Thank you for your testimony. Next, we have Eid Ali. Welcome to the Senate Labor Committee. If you'd please introduce yourself for the record and then proceed with your testimony.
Thank you, Madam Chair and members of the Labor Committee. My name is Eid Ali, and I am the president of Minnesota Uber and Lyft Drivers Association. Thank you for granting us this opportunity to address the Senate Labor Committee today. Over the past 2 years, Uber and Lyft drivers have been tirelessly advocating for fair wages, facing significant resistance for those multi-billion-dollar corporations. Despite the corporate opposition, we have found support among elected officials at both state and local levels. Through our efforts, we have successfully convinced them that Uber and Lyft were constantly paying us below the Minnesota state minimum wage of $10.85 per hour. Our ongoing journey has uncovered concrete evidence of deliberate underpayment, further substantiated by the recent final state report exposing a decade-long pattern of exploitation. Notably, the city of Minneapolis recently voted overwhelmingly in favor of establishing local minimum wage, underscoring the urgency and necessity of addressing this issue at the grassroots level. Returning to you after a year, we seek your support in advocating for fair wage and just treatment for the drivers who have endured these challenges for too long. The evidence is clear, and we trust that you, as representatives of the people, will work towards finding solutions for our fellow drivers, our brothers, sisters, uncles, sons, and neighbors. The committee's decision is crucial in rectifying the injustice faced by the drivers. We call upon you to vote in favor of this. We call upon you to vote in favor of fair wage and fair treatment, putting an end to the exploitation that has persisted for too long. Thank you once again for this opportunity. We appreciate your time, consideration, and commitment to resolving these issues faced by the drivers.
Thank you for your testimony. Next, we have Shannon Perry, and after that, Joel Carlson. Welcome to the Senate Labor Committee. If you'd introduce yourself and proceed with your testimony.
Thank you, committee. My name is Shannon Perry. I'd like to start out by saying this is not a color or gender issue. This is a driver issue. Drivers have been with us since before the pandemic, helping close the gap. This concerns all drivers for the gig economy run businesses. I'd like to speak with you about concerns that I have involving app-controlled industries originally constructed to fill gaps and help the people in our communities. These businesses are Uber, Uber Eats, Lyft, Grubhub, DoorDash, and other gig app-based services. They are self-serving, running exploitation, slave labor, and unaccountability. Deactivation for standing up for rights, safety issues, and treating us like employees. We are not drivers with a choice. Their use of fear tactics must be stopped. Will you stand with us? Uber and Lyft are charging drivers for their commercial insurance. Should essential workers start a union to avoid having to fight for new laws for protection with the Department of Labor? Drivers are essential workers and independent contractors dealing with recession, unjust retaliation, and severe financial losses. We are labeled as independent contractors without any rights. We want to receive fair pay per mile and pay for our time. We need this for our time, our maintenance, our insurance that we have to pay for in order to transport Minnesota's food and people to and where they need to go. We want to stop being aggressively punished for not accepting extremely unreasonable fares or canceling rides for an explicitly appropriate reason. Drivers are willing to come to the table, but so far it's all been one-sided. We need competitors in our market. We need this to have the people, along with myself and applicators and programmers, and they are there ready to be used. Should Lyft and Uber decide to pull out, we have those in place. Drivers put their lives at risk every day, and we are the face of these companies. These Goliath and monolithic huge companies are new to this world. Since the development of apps, web sharing, and laws need to change. We are not in the Wild West. There has to be accountability. We cannot work as team members in this world without coming to the table and celebrating each other's gifts. While Uber and Lyft do not call us employees, they are constantly taking away our rights. They're categorizing us, they're disciplining us when we don't pick up bad rides. They're profiting off of AI algorithms and profiting on our backs, the backs of drivers, the backs of the people that voted you into office. They're showing themselves as unaccountable when it comes to devastating personal implications and damages on the drivers after any fact. This includes assaults, this includes murders, loss of income, accidents, retaliations, and financial problems concerning wear and tear and maintenance of our own vehicles. Let me close in saying that I love my people. Sorry. I lost many people during the pandemic. And I served Minnesota by bringing people food and transporting people to places they needed to go. And I took my time talking with the people and keeping my finger on the pulse of society in my neighborhood. Sorry. I want what every person wants, to have fair pay, security, accountability, and respect for the jobs that we do. And let this be my prayer and my stone. Thank you.
Thank you for your testimony. Next, we have Joel Carlson, and after that, John Reich. Welcome to the Senate Labor Committee. If you'd introduce yourself and proceed with your testimony.
Thank you, Madam Chair and members. I'm Joel Carlson. I own a legal research and government affairs business in St. Paul, and I'm here on behalf of Uber Technologies, a company I've represented since they first came to Minnesota in 2012. I would like to, and I've said before, and I said all summer long, how much drivers mean to this company and how important they are. And so issues of exploitation, we take those comments very seriously, and that is nothing that this company embraces. And so a lot has happened since I was here March 8th of 2023, Madam Chair, is when you issued your committee report on this bill last year. We've had hours of hearings. The governor appointed a task force that met every 3 weeks this summer. I attended every single meeting. We've been through data requests. Uber and Lyft provided 19 million rides of data, the biggest study that has ever been done in the history of rideshare that we have worked on cooperatively with the state. We've been to the city of Minneapolis. We had task force recommendations that were by consensus, and I want to talk about some of them. And so I want you to know that Uber and Lyft, Mr. Wright can speak for himself, we want to have a minimum compensation level. We want it to work for our drivers, we want it to work for riders, and we want it to work for the companies. There are some very important things that need to be resolved for that to happen, including, as the last testifier just said, how they're classified and what rights they have under the statute and under their operating conditions. Those are important things that have to be addressed. As to the bill, Madam Chair, it's been suggested that this is a consensus bill that contains the consensus items from the task force. And I have to tell you that that is just kind of not exactly accurate. The first 8 pages of the bill deal with insurance, and I can tell you that many of those provisions were never discussed or agreed to at the TNC task force. But when you get to page 8, there are a number of things that came out during the task force process of pay transparency, deactivations, how those are handled. And many of those are embodied in pages 8 through the end of the bill. And while there are some differences in those in that language, Madam Chair and members, many of those things are consensus items that we all agree on should happen. There are some differences on page 14 that were not really discussed. In fact, it's Task Force Recommendation 19 that we should have further conversations about prior deactivations and how those are reviewed. We never brought up private civil cause of action. We never talked about arbitration. We didn't talk about discrimination, but we absolutely support that provision on page 15. And we have an ongoing problem and really an issue for the state to address. We are one of the few states that does not have a statewide regulation for transportation network companies. I think it's 43 or 44 other states have a statewide system of regulation. We have done that locally, and our companies have supported those local regulations. So we've been to Duluth, and we've been to Minneapolis and Rochester and Moorhead and Mankato to get local ordinances. We don't have a statewide system for managing transportation network companies. We maybe should, but when it comes to enforcement, we don't have an entity that regulates us. And so leaving this to local units of government, I think, is too much of a burden for them to handle, and we do need to close that loop. And lastly, Madam Chair and members, on the A1 amendment, I appreciate author's amendments, and he can put the bill in whatever shape he wants, but to suggest that that is either, that rates that are in there are either embraced by the significant rate study that was done or by the companies and were discussed at the task force is just not accurate. In fact, the base rate that the state study came forward with of 48 cents a minute and 89 cents a mile is substantially less than what the amendment that you just approved. Is very close to the ordinance that's being discussed in Minneapolis right now, which we think will have severe consequences and force companies to be economically unviable and unable to operate. So that amendment is absolutely out of line with what we can support, and so we're happy to have that discussion. Last point, clarifying driver independence is extremely important. There isn't a single jurisdiction in the country that hasn't clarified employment status when they've done a wage compensation bill like this. That is critical for the companies. It's critical for the employees, for the drivers, and so that issue needs to be discussed. We did discuss it at length and could not reach consensus at the task force, but it's something that I think the legislature needs to address. Thank you, Madam Chair, and we're happy to answer questions.
Thank you for your testimony. Next, we have John Reich and then Omar Adden.
Good afternoon, Madam Chair and members. Thank you for the time today. My name is John Reich with Coastal County Public Strategies. We represent LIFT in Minnesota. And there, as Mr. Carlson mentioned, we agree with many of the comments that he made, but I would also want to say as a top-line theme here that if LIFT doesn't have drivers, we don't have a service. The drivers are important to LIFT, and any mistreatment or allegations or anything like that we take very seriously. And it's against our own interest to not have drivers engaged in our app, because then we cannot offer the service. The second major point I'd like to make is that we are committed to working through this process with the stakeholders. We support the recommendations that came out of the task force. I think they've now been put into bill form, as we can see here. Anytime you take recommendations that are broad, that are consensus-based, and put them into bill form, there are details and other things that we would like to work through with the author on that, and we would appreciate the engagement with him. We have an outstanding request for a meeting, and I think we'd like to discuss those further. Madam Chair and members, I'd also like to discuss LIFT's engagement in the state for the last 8 months. We have continually engaged with stakeholders since the end of last session. We've participated in the task force. We, as Mr. Carlson mentioned, produced the most data ever in the history of rideshare to be studied by the Department of Labor and Industry, which then came about in the wage report that you all, I'm sure, have seen. We have also worked with drivers to improve our platform. We have now instituted a $5 minimum fare ride for every request at the request of drivers last year. We've also made deactivation changes to our platform, and we launched a partnership with Malta that allows drivers to receive in-person translation services, and we're eager to build upon that partnership in the future. We also recently announced a new pay floor guarantee. Our data shows that drivers generally take home 88% of the fare, but we've now guaranteed that they'll get at least 70% of the fare in aggregate over the course of a week after fees. So if you are a driver that goes through the course of a week and falls below the 70% fare minimum after fees, we will top you up at the end of the week. We also have introduced a new streamlined in-app button for drivers to appeal deactivation decisions right from the app. This gives drivers the ability to provide LIFT with any new or updated information to support their appeal, as well as direct access to a specialized support team. This was piloted early in Minnesota in March and is now a nationwide initiative on the part of LIFT. I know I'm running up against my time. I'd like to just leave the committee with one other point. Many of the issues Mr. Carlson raised are ones we share, and we very much are interested in working through those issues throughout the course of the process with the author and any other interested stakeholders. Thank you, Madam Chair.
Thank you for your testimony. Next, we have Omar Adden. I'm not seeing Mr. Omar Adden. Not here, perhaps. Then next on our list, we have Commissioner Nicole Blissenbach of the Department of Labor and Industry. Welcome to the committee, Commissioner.
Thank you, Madam Chair, members of the committee. My name is Nicole Blissenbach. I'm the Commissioner of the Minnesota Department of Labor and Industry. As you know, our agency has been engaging stakeholders on this topic for the last year, formally through the directives of the Governor's Executive Order 2307. That executive order was issued in May of 2023 and directed me as the Commissioner of the Department of Labor and Industry to commission and oversee a study to obtain and analyze data and information related to the working conditions of transportation network company drivers in Minnesota and how potential changes may impact access and cost for riders. In addition, the executive order established the Committee on the Compensation, Well-Being, and Fair Treatment of Transportation Network Drivers. The TNC committee met over the course of 6 months to collect and analyze data and information related to the working conditions of TNC drivers and to draft recommendations related to compensation and fair treatment of TNC drivers. The work of the committee concluded in December of 2023 with a set of 24 consensus recommendations to the governor. The committee was made up of 15 members, including TNC representatives, TNC drivers, drivers representatives, local and state government leaders, and other relevant stakeholders. Commissioner Arnold with the Department of Commerce and I served as the co-chairs of the committee. During public meetings, our committee heard directly from drivers, companies, cities, driver representatives about the experiences of driving for a transportation network company in Minnesota. The committee organized recommendations around 5 topic areas: pay transparency, minimum compensation, deactivation and due process, driver support, and insurance. I'm here to share that the administration is fully in support of the 24 consensus recommendations that were outlined in the committee report. The bill today does contain policy that was not included in the consensus recommendations of the committee, and at this time, the administration can't take a position to support anything that wasn't, or anything beyond the recommendations until we have an opportunity to receive broader stakeholder input and agreement. At the same time the committee was meeting to build consensus for TNC policies in the state, DLI was implementing the second part of the executive order to commission a study. The study was published on March 8th of 2024, just last week. That report, TNC Driver Earnings Analysis and Pay Standard Options, offers a range of pay standard options to calculate minimum compensation for TNC drivers that cost out basic expenses and more comprehensive benefit expenses. The analysis used Minnesota TNC trip data from 2022, a set of more than 18 million rides, a TNC driver survey, and Minnesota-specific expenses and benefits data to determine a range of options for a pay standard. Now that the study is complete, the administration is committed to engaging with stakeholders and authors to build agreement on a pay standard that is supported by the report. I fully believe that with time and effort put towards building stakeholder agreement, we can get to a bill that has broad support. Thank you.
Thank you, Commissioner. That concludes the people who had signed up to testify. One more time, I just want to make sure Omar Adden. I don't see Mr. Omar Adden. Okay. With that, then that concludes our testifiers for today's bill, and we'll go ahead and move to discussion. Before we do that, yes, Senator Fateh, do you want to leave us with any thoughts or comments?
Yeah, just 2 pieces. There's actually several, but I'll only highlight 2 in the interest of time. One comment from Uber and one comment from Lyft. One comment was, I did not indicate that the rates were set based off of the task force recommendations. The task force failed to come up with a recommendation, and because of that, DLI was getting some data. We plugged these in based off of the data that was presented within that report. Number 2, Lyft said that there is an outstanding request, that the meeting was sent an hour ago. It's not outstanding, so I just wanted to put that out there, that we're willing to work and negotiate and work with all stakeholders.
Very good, thank you. And just for clarification, the figures that we're all talking about in regard to the study, those are the figures that are reflected in the A1 amendment that was adopted earlier?
Correct.
Okay, thank you, Senator. With that, members' discussion. Yes, Senator Wiesenberg.
Thank you, Madam Chair. I just have a few questions I guess I'd like to have answered. So how often did you meet with the governor's task force as the appointed senator for this?
Senator Fateh.
Thank you. My name was withdrawn as a member of the task force, so I was not a member of the task force, but I met with the members regularly throughout the summer.
Senator Wiesenberg.
And Eid was a member of the task force. Thank you, Madam Chair.
Yep.
Thank you, Senator Wiesenberg.
Yeah.
Thank you, Madam Chair. Whom from the Senate worked with the governor, the House, the drivers, and the business on this task force to get the deal done this summer then? Thank you.
Senator?
Thank you. Thank you for the question. You're saying who from the Senate?
Yes, Madam Chair and Senator Fateh, whom from the Senate worked with the governor to work on this summer?
Thank you so much. Thank you for the question, Senator, and thank you, Madam Chair. I worked myself with the task force members. Leader Dzik was also part of those conversations, or that time, Leader Dzik. We met with the members regularly. We met with the commissioner, the governors, the administration commissioners of DLI as well as Commerce. So we've been having frequent meetings with all stakeholders throughout the summer, and including myself.
Follow-up, Senator Weisenberg?
Not at this time, thank you.
Okay. Senator Kubek?
Sure. Thank you, Madam Chair. I just, maybe just a quick clarifying question, just to maybe further my thoughts of where we're going with this. What is the path of where this bill is going, and then does it come back here? I guess is the other question.
Thank you.
Yes.
Thank you, Senator Kubek. I have on our agenda that next the bill is to be re-referred to Commerce. After that, it also has to make stops in Judiciary and then Finance. So it still has some stops after this. I don't know if it will be coming
Sure,
back
so-
this way or not.
So, Madam Chair, then, yeah, either back here or to the floor conceivably.
Correct.
Okay,
Yeah.
thank you.
Yeah, thank you. Senator Weisenberg?
Thank you, Madam Chair. Did you ever meet with Uber or Lyft this summer?
Senator Fateh?
Thank you, Madam Chair. We met with them in the past May at the end of session. Throughout the summer, I let the drivers lead that conversations because they made a request that they wanted to be at the forefront. I respected their wishes. They wanted to meet with them in and out of the task force, and I waited. And as myself being the chief author, yes, I am the chief author, but this is a product that will affect the drivers, and I let them lead these conversations.
Senator Weisenberg, follow-up?
Yeah, thank you, Madam Chair. So just to be clear, you yourself did not meet with Uber or Lyft and talk to them about this issue?
Senator Fateh?
Thank you, Madam Chair, and thank you, Senator Weisenberg. I did not, and they did not request it. They made a commitment to participate in the task force, and thank you. They made a commitment to participate in the task force along with Lyft, and so with that, Mr. Steve Cooper and Mr. Eid Ali regularly met with them as well.
Thank you.
Senator? Okay. Senator Dornick?
Thank you, Madam Chair, and I just want to thank all the drivers that came today. Thank you for coming. Thank you for your work. Thank you for testifying. We appreciate you coming in and giving your personal testimony. Thank you, Senator Fateh, for the bill. This has been a bill that's gone through a lot of work. We know we've done a lot of work on it, and the task force that was 15 members. I guess I wanted to talk a little bit about the task force. A question for you with that. Let's see, it was 24 recommendations that were made, and this bill that came to us here from the testimony of the commissioner, there were some things that weren't quite added, or maybe they were added that weren't in the recommendation. So just tell me how this bill came to the language that's in it now with the task force, and just varying away from that a little bit.
Senator Fateh?
Thank you so much. Thank you, Madam Chair, and thank you for the question, Senator Dornick. So the task force came up with recommendations that needed to be put in bill form. We met with House leadership and Senate leadership. We met with House counsel and Senate counsel to put regularly to build consensus among the members in the House and the members of the Senate to put the recommendations in bill language. There was areas that there was not any recommendations that there was not agreement on. And those details had to be figured out, for example, through the data that was provided to DLI.
Senator Dornick?
Thank you, Madam Chair. Thank you for that. So I guess I know the one thing that sounds like is the issue is the independent contracting title. So with that, where are you with that? One of the testifiers had mentioned that most or many states, I'm not exactly sure what he said, clarify them as independent contractors. Not only, well, we don't want to face misclassification for the businesses, but we also want to be flexible and make sure that you guys have the freedom to be able to operate as self-employed or independent contractors.
Senator Fateh?
Yeah, thank you so much. now, this language is intentionally set so that we don't touch the status of independent contractor versus the employees. It was something that was not agreed upon by the task force as well. There was several members that were against having it one way or another. House members also were against that, but I can also let Mr. Cooper elaborate as well, if you'd like.
Mr. Cooper, if you have additional information to add, we'd appreciate it.
Just a slight amount, I think the senator covered it, but basically there was very strong opposition from the House and particularly the majority leader. There also was very strong advocacy for it by Uber and Lyft. Those points of view came to the point where there'd be no bill if either side won on that issue. Basically, there was a feeling on the part of the one side that it absolutely is improper to create a new classification for independent contractor. They either are or they aren't under the existing definition. That was kind of a hot button issue. It's not one that would ever be agreed to.
Understood. Follow-up, Senator Dornick?
Thank you, Madam Chair. I was wondering if I could call Joel Carlson back to get a little bit more fleshed out on the concerns that they have.
Thank you. Please proceed.
Thank you, Madam Chair. Mr. Carlson, just you had mentioned the many other states have it, so just a little bit more details on some of what other states are doing and some of the concerns and how we can navigate through this and maybe come to a peace in the valley on this subject. It sounds like it's a hot button is what is spoken. So.
And Senator Dornick, are you referring specifically to the issue of independent contractor versus employee, or are you talking generally broadly about the bill? Just wondering about the scope of your question.
Thank you, Madam Chair, for that. The independent contracting issue specifically,
okay.
Yes.
Thank you, Senator. Yes, thank you, Mr. Carlson, for joining us. Yes.
Thank you, Madam Chair and members. I'm going to answer the independent contractor question directly, Senator Dornick, but I'm also going to tie that back to the rate that was approved in the A1 amendment because I think it's relevant to this conversation. Madam Chair and members, there isn't a state in the country that doesn't classify or treat these TNC drivers as independent contractors. In fact, the rate study that was just completed by the state over all these rides clearly establishes that they're independent contractors. So to suggest that this is some wild, crazy idea is just not really accurate. It is important for the drivers that they are independent and flexible, and it's important for the companies that they're independent contractors. There are over 5 million drivers on this platform. We cannot manage a staff of 5 million people with shifts and all of the things that go into it. We can't have them leaving for 2 months to be gone from the platform and then come back and work. That is how the independent nature of this work has grown and developed, and I believe not only is it what the companies want, I think it's what the majority of drivers want as well. But the problem that I have, and this A1 amendment has made it worse, you really need to look at the rate study that Commissioner Blissenbach mentioned. The rate in that study for the metropolitan area is a per minute number of 48 cents and a per mile number of 89 cents. That is not what you have in your A1 amendment. If you take the very highest numbers that you can that they found, some for outstate Minnesota, you can get to $1.39 and 42 cents. But what do you have to pay to get that? Earned sick and safe time, paid leave, health insurance, retirement savings, and unemployment insurance. That sounds like employment to me. So you're setting whether you are or not an independent contractor it's determined by the work, how you're paid, what your contract is. Are you responsible for your own expenses? You set a pay rate in the A1 amendment that factors into the equation paying all of these employment related benefits. And so I would suggest to you that without clarifying their status, you will make them employees by including those factors on page 11 of the state study, and you've created an employment situation simply by making us pay by the hour, which is one of the factors for independent contractors, and making us reimburse for expenses, a second plank in the independent contractor nature of work. So this is a real problem. I agree that the task force couldn't come to an agreement on it, and we know that the legislature is the proper place to decide that. That is for you to decide. We have a statute right now, 176.043, that relates to part of the drivers up here today, couriers, truck drivers, delivery people. Uber Eats is very clear in statute, independent contractors. We should have clarity for drivers as well.
Thank you for that. And as long as we're on this issue, do you mind, Senator Dornick? I have some follow-up on that, and I'll let you, of course, have follow-up as well. And before I do, Senator Fateh or Mr. Cooper, if you had any brief comment, we would welcome it.
Go ahead.
Madam Chair and members, the opening remark, the closing remark and opening remark are interesting. There's nothing new in the manner in which people are paid. They're paid by the minute now. He said by the hour, but I think he meant by the minute. They're paid by the minute before. So there's no change there. When he says that changes status all by itself, it doesn't. The second thing that's interesting is he says there's no question we're independent contractors. Then why do you want to put it in statute with a different standard? I mean, there is a standard for independent contractors that's in the law, both federal and state, and it's very clear. He wants to create a new standard that's a very different one. If you were confident of your status, you would not need to change it. I think that's the only issue you asked me. Did you want me to expand to the pay one or stay away from that for now?
That's all right. We'll try to keep our conversation going. And that was my reaction as well, is that we do have mechanisms within the law for determining, we have a test to determine whether someone is an independent contractor or an employee under the law, and I am sort of at a loss as to why we would need to specifically enumerate it in this particular statute. And I also would note that my understanding of these rates reflect that people are making their living on these rates, and whether they're classified as independent contractors or employees, whichever way they're classified, you're talking about if they're being treated as independent contractors, they are not receiving things like earned sick and safe time, like retirement benefits, like health insurance, like all of the things that people need in their lives to live. So that higher rate would reflect that as so-called independent contractors, they're going to be responsible for paying for all of those things in their lives. They're going to need to be paid much more than a basic minimum wage that a worker who's making minimum wage would be making, who does get some of those benefits. So that's my understanding of the rates, and I just wanted to make sure that people understood that range reflects in parts some of the categorization issues that we're discussing today. Yeah, and Mr. Carlson, if you have a brief response, feel free to respond if you have something brief.
Briefly, if that were the case, that was who was required to pay it, it doesn't say that in this bill, number one. But number two, the rate's $1.20 for that comprehensive package. It's not $1.39, right? It doesn't reflect even what the state said they would have to reserve for those expenses.
But I believe that's for out in greater Minnesota. I believe that's the number.
Madam Chair and members, if you're going to follow the task force recommendations, it called for a bifurcated rate, and that's why this report is in two different rates. You didn't put the metropolitan rate in the A1 amendment. It's just not there. Even at the comprehensive rate, it's just not there. And in states, they do reserve for earned sick and safe time and other things. It's not clear who's supposed to pay it in this bill. Is it an obligation of the company, or is it an obligation of the driver? It is not clear in this. It's not in this bill at all.
Thanks for the follow-up. I'm going to go back to Senator Dornick. Senator Dornick, do you have follow-up?
Thank you, Madam Chair. Thank you for the answers, for the dialogue there. And it sounds like we still have a ways, excuse me, a ways to go. We have the task force, they have their recommendation, we have the bill, and then we have some concern on Uber Lyft. So I would encourage Senator Fateh to continue to work on this. Last year, you know, we got it through the legislature, Senate and the House, but then the governor vetoed it. So we definitely want to get a bill that works. So it sounds like there's some issues yet we need to go through. So I'm more than happy to meet. I know we met last year. So with that, Madam Chair, I'll let others. I do have an amendment, but that can be later.
Thank you, Senator Dornick. Yes, Senator Grunhagen.
Oh, thank you, Madam Chair. Yeah, thanks for the testimony. It's a little bit of a learning curve, but my question is for Joel Carlson also. If I understood the testimony correctly, there's over 40 states that have a statewide law in terms of Lyft and Uber. Is that correct?
Mr. Carlson.
Madam Chair and members, yes, I can get you the exact number, but it is in the high 40s. And I can give you, I have a listing of the states. I just don't want to say it was 41 because I want to make sure I get the right number to you. But yes, we are, and I can tell you that we're the only state that regulates these at the local level. The states that don't have a regulation don't regulate them at all.
Senator, follow-up.
Oh, thank you. Thanks for the response to that. So, you know, I do lean towards a statewide program, okay? But in those states, as far as you're aware, has Uber continued to operate in those 40-some states that had a statewide law that pertained to the transportation and Lyft?
Mr. Carlson.
Madam Chair and members, Senator Gruenhagen, yeah, absolutely. There are a very small number that have set a compensation level like is in this bill. New York, California, Washington State, you know, they're in the, those comparisons are in the study, the rate study as well. Each of those jurisdictions have clarified the employment status for the drivers because they're changing the way that they are compensated. So of the jurisdictions that have set a rate like this and doing it in an ordinance or a statute, they have clarified the independent nature of the drivers.
Senator Gruenhagen, follow-up.
Oh, thank you, Madam Chair. Yeah, thanks for that response. Yeah, I guess, you know, of course, I'm a layperson. I have used Uber and Lyft in the past, and it's been a nice convenience. And obviously, we want people to be compensated properly. But I think when looking at this bill, it seems like it goes a little too far to start with, okay? And that there's some confusion as far as independent contractors versus employee and what benefits apply. So I think the bill does need quite a bit more work. I do support the idea of having a statewide standard. To have this patchwork that we have right now probably isn't the best, you know, for everybody concerned over the long run. But to do it in such a way as to endanger whether Uber and Lyft continue to operate in this state, I think needs serious consideration, because obviously if they would decide to leave, you know, whether it's a real threat or an empty one, it looks like in other states that had a statewide program, they continue to operate. And I think by working with them to come with a base plan initially would probably be the best for all concerned. Those are my thoughts. Thank you, Madam Chair.
Thank you, Senator. Further discussion, Senator Wiesenberg.
Thank you, Madam Chair. I guess it's I just have a comment. I know I used to work for the Department of Natural Resources, and I didn't get along because I didn't feel like they were following the science the way they should, so I quit my job, and I started my own wildlife research company. So people have the opportunity, if they don't like where they're working, to start their own business. I think Uber, Lyft would say, go ahead and start your own business and try to compete. That's America. We have capitalism. If you don't like Uber, Lyft, then let's form an organization and you could start your own thing and you could give your employees what you're asking for. If Uber, Lyft can't give it to you, then start your business and do it. So I guess, you know, we're trying to regulate Uber, Lyft when we could just say, you know what, let's just do it ourselves. And that's what I do. I started my own business and I worked for myself. So that's what we could do. We could encourage people to get together and then start your own thing. So, thank you.
Thank you, Senator. Okay, I'm not seeing any further discussion. If we would want to move on to an amendment that Senator Dornick, you had an amendment?
Thank you, Madam Chair. So yeah, I'd like to move the A2 amendment.
Thank you. Senator Dornick moves the A2 amendment. Is that in our packets? Needs to be passed out? If we could have the A2 amendment passed out, and while we're doing that, Senator Dornick to the A2.
Thank you, Madam Chair. So this just specifically titles a TNC driver as an independent contractor for the purposes of not an employer or agent with respect to the TNC driver relationship with the transportation network company. And as it was said, and also I had mentioned that we don't want to misclassify this and to have a risk of the employer or the employee. We want to protect both, to have the flexibility of what they are if they're truly independent, and then also to protect the misclassification. I know we had mentioned by one of the testifiers about some of the tests and stuff. So this just clarifies, puts it in, and I did hear that the House isn't a fan of this amendment or the Senate, so I'll give you an opportunity, Senator Fateh, to agree or disagree. So thank you.
Senator Fateh?
Thank you so much, Madam Chair, and thank you, Senator Dornick. I am going to recommend a no vote, but this is something that I believe, if in place one way or another, there would be no bill. There are folks that have strong opposition to this, but I'll let Mr. Cooper also elaborate as well.
Mr. Cooper?
Madam Chair, members, listeners, this is very, very bad for a number of reasons. First, I think, and Joel can correct me or incorrect me, I think when he was talking about 40 states, he was not talking about 40 states that have them as independent contractors. What he was talking about is they have legislation about TNCs. And if I'm saying that wrong, Joel, correct me. But it's wrong. Okay. The key thing here is that when you, even in the bill that they proposed, there's lots of terms that say what it is that constitutes an independent contractor, even in this context. And this has no definition. So if in fact you say they're independent contractors, and immediately they put everybody on schedules, and immediately they say if you're not in, you can be fired, there's no protection for that worker. We've dramatically reduced their protection because there's nothing in this language that even attempts to track the state and federal language of what an independent contractor is. I think when you start to wander in a case-by-case basis of trying to use new and different definitions, or as in this case, no definition at all, every single business is going to be here saying, let us call our employees independent contractors. Just say it by statute that we're independent contractors. This language, it's not that it can't be talked about later, but this language does not have any of the protections that every other statute has that talks about independent contractor status. And as I said before, the state has several very clear independent contractor statutes that have tests. And even Uber and Lyft have never asked for one without a test. So I would point those facts out.
Thank you. Very briefly, Mr. Carlson, I want to move to discussion with members.
Thank you, Madam Chair and members. If you want the test, you can improve your amendment by just saying, after company on line 1.4, if they comply with Minnesota Statute 176043. That is the test.
Then why do we need another one?
Thank you. Thank you. Senator Dornick, would you like to respond at all?
Thank you for that. So yeah, I would amend my.
To make an oral amendment to your amendment?
Yeah, Ms. Fontaine would help a little bit, put you on the spot. Thank you.
If Mr. Carlson could repeat the citation on line 1.4, before the period, insert if they comply with section 177.
176.
176.
043.
.043. And Madam Chair, Mr. Carlson, is that a workers' compensation statute?
It is. It's the test for delivery drivers, truck drivers, and other transit-oriented drivers that are doing independent work.
Senator Dornick, is it your intention to make that oral amendment?
Madam Chair, yes, thank you.
Okay.
I'd like to incorporate.
Incorporate it?
Yes.
Okay, very good. We don't need a motion for that? Okay. Ms. Fontaine, could you please just make sure that we're all on the same page about what the A2 now says with the change that Senator Dornick made?
Okay, Madam Chair and members, I believe the intent is to clarify that the independent contractor would comply with the section cited for workers' compensation independent contractor test. So on line 1.4, before the period, insert if the TNC driver complies with section 176.043. And Madam Chair, Mr. Carlson, is referring to the work of the TNC driver or what they're doing? So when you say they, we're meaning the TNC driver?
Madam Chair and Council, I believe that's the case, yes, because it is a requirement for the employee to meet those tests. The employer has to meet them as well, but it is a test for the employee.
And Madam Chair, I can repeat that one more time. I mean, I could read the whole thing. I just want to make sure within context that we're understanding that the they that was stated earlier means the TNC driver. So again, on line 1.4, before the period, insert if the TNC driver complies with section 176.043.
Council, I
Okay.
think that.
Senator Fateh, did you have any comment on this amendment as it has now been changed?
No, it doesn't. This bill doesn't, but the question she
Thank you, Madam Chair. I will still say no. I appreciate Senator Dornick for the amendment and the amendment to the amendment, and I'm willing to work with you, but I also allow Mr. Cooper to briefly explain why as well.
Okay, thank you. Yes, briefly, thank you.
I'll be extremely brief. I'll be on that one word. I oppose it altogether, but on that one word, I'm sorry, Madam Chair, members, on that one word, he says that the driver should be in compliance. No, it's the company that should be in compliance. And if there's disagreement, put both, but it's the company that has to comply.
Okay, thank you, Mr. Cooper. Is Commissioner Blissenbach still here? Commissioner Blissenbach, could you please join us at that table? Commissioner, I just wondered if, in your capacity as representing the agency, if you had any comment about the statute that's being referenced in the amendment or any position. Thank you.
Yes, Madam Chair. So the specific provision that was being referenced is a provision in the work comp statute that talks about whether or not somebody is an employee and therefore needs to be covered under the workers' compensation provisions. So I'm not going to say that I'm an expert in that area, but I can get back to you on specific questions on how that would apply.
Okay, thank you. Members, yes, Senator Liskey.
Thank you, Madam Chair. Madam Chair, I think this is more of a comment than it is like a question. I know we just heard about misclassification and we talked about, all the things that were coming with that, and there's going to be significantly more punitive issues if you misclassify your employees. I can see where Uber and Lyft are concerned, where all the TNCs would be concerned that if for some reason Dolly were to see this as an employment situation instead of as a independent contractor situation, we could run into some pretty expensive issues for those companies very fast. And I think that's why they're asking for this, is to avoid those types of things. And so I'm in support of the amendment because of those things, being worried about those types of issues.
Thank you, Senator Liskey. Senator Umer Verbatim.
Thank you, Madam Chair. Yeah, I think they're asking for this so that they can continue a model where they don't have to pay for all sorts of benefits or or be subject to the sort of protections that employees are. And I get that the bill is not necessarily speaking on that, but I think it would be a disaster to put in statute that they are independent contractors at this point.
Thank you, Senator. Any further discussion? Senator Liskey to the A2 amendment.
Thank you, Madam Chair. After Senator Uma Brayton's comments, I'm a little concerned that we're heading towards an employment thing then. And I don't know that Uber and Lyft are interested in hiring employees. They're an operating company that allows independent contractors to use their services. So if we're headed that direction, at that point, this bill doesn't do either. And so I'm concerned that if we are headed that way, we should head that way. If we aren't headed that way, we should be avoiding those situations. So with that being said, that's, again, why I'm in support of this.
Thank you, Senator. I think that everybody has said what they have to say, so I'm going to go back to the amendment. Author, Senator Dornick.
Thank you, Madam Chair. Thank you for the discussion. I just ask for a roll call and ask for your support. Thank you.
Thank you. Roll call has been requested. A roll call will be granted. With that, the A2 amendment has been moved by Senator Dornick with an adjustment, a change that has been noted on the record. To the A2 amendment, please take the roll.
Chair McEwen.
No.
Vice Chair Hoschild.
No.
Senator Dornick.
Yes.
Senator Gruenhagen.
Yes.
Senator Kupek.
No.
Senator Liskey.
Yes.
Senator Marty.
No.
Senator Umu Verbaeten.
No.
Senator Pappas.
No.
Senator Wiesenberg.
Yes.
There being 6 noes and 4 ayes, the amendment does not pass. Members, are there any other amendments or any further discussion on Senate File 4780 as amended? Yes, Senator Liskey.
Thank you, Madam Chair, and everyone else. It's unfortunate that that amendment did not pass, as I'm now concerned that we are headed down the path of trying to make these drivers as employees or have employee qualifications. And so with that being said, it makes me concerned that Uber, Lyft, any other TNCs are going to now pull out from the state of Minnesota. And if they do, what does that mean for those that rely heavily on this type of transportation? What's going to happen to those individuals that will now have to try and find a new ride? And so with that, I'm really concerned about where this is headed.
Thank you, Senator. Yes, Senator Gruenhagen.
Oh, thank you, Madam Chair. Yeah, I guess I would simply say I identify with Senator Liskey's concerns on the bill, and it seems like we're trying to head down towards an employee status versus a independent contractor. And with that, I have strong concerns whether or not Uber and Lyft are going to stay in the state and provide the services that are so desperately needed. So I, too, have those concerns. I do have one question yet for either Senator Fateh or Joel Carlson, and that would be, you know, we had some testimony about unfortunate incidences that happened with passengers, and who's liable in that particular situation if an unfortunate incident or something real negative happens? Is Uber and Lyft liable in any ways, or is it the driver, or it falls on his auto insurance, or how does that work?
Senator Fateh, or I'll turn it to Senator Fateh first, and then we can also go to you, Mr. Carlson. Did you hear the question?
Yes, I believe as things stand right now, nobody, but I could pass it off to Mr. Cooper also as well briefly.
Briefly.
Madam Chair, members, right now, and that's part of what this bill is addressing, right now, if it's an injury that takes place outside of a driving time, like, for instance, you get out of the cab and you get, like some of our people have been stabbed and shot, there is no protection from anybody that falls on the driver or it falls on welfare. But it does not, Uber and Lyft have absolutely no responsibility as of today. After today, if this bill passes, then there's rules that are set out in the statute.
Okay. Mr. Carlson?
Madam Chair and members, Senator Gruenhagen, It's not a white or black answer. It depends on if the injury happens or arises out of the use or operation of a motor vehicle. There could be coverage, there might not be. But we have identified that there have been injuries that are not related to the motor vehicle, and there's a gap in coverage. Uber and Lyft both have employee, you said, there I caught myself. Have funds to assist drivers. It's not a replacement for full insurance. And if you look in the agreement, although it's not language we are yet supportive of, and in the TNC task force report, it's an area that we hope to close that gap to make sure there is coverage if there's an assault or something that happens outside of the operation of a motor vehicle.
Thank you. Thank you, Senator. Any further comments? Yes, Senator Kubek.
Sure. Thank you, Madam Chair. Yeah, I want to just make a couple of comments because the last amendment, I think I get also where Senator Dornick is going with this, and I do think that a lot of the drivers for Uber and Lyft appreciate that part of that independent contractor status that allows you that flexibility to, here's when I want to work, these are the days I want to work. There is that, and that is I think the really great part of what Uber and Lyft have provided is that worker, flexibility. But I was a little hesitant, wasn't quite sure what the ramifications were of this, and that's why at the beginning I also asked, where the other stops were. So I appreciate what the task force has done. I think we've come a long way from where we were a year ago here, but I feel like there's still a couple of more tweaks that could be made to this, and I'm hopeful over the next few stops that those will happen. So thank you, Madam Chair.
Thank you, Senator. Okay, not seeing any further discussion. I just wanted to also say a comment. I wanted to thank all of the drivers today for coming to the Senate Labor Committee to share testimony and also thank everyone, including especially the drivers who've remained in coalition and meeting together to make sure that your voices are heard and that the bill that is moving forward now does reflect the things that you're asking for. And in spite of what legal boxes we put things at the state legislature, you're letting your lead author and the coalition know what it is that you need, and then we're going to try to make sure that the final version of the bill does indeed represent what you are asking for and what you need. What I see in all of this is that we're arguing about the idea of classification and an independent contractor employee and how that's going to go. And I think this bill really does cut to the heart of a lot of the problem, which is that this is a problem, right? This is a problem. This is a problem for workers who are classified in this way, who may enjoy a lot of the flexibility and some of the benefits therein, but there's a lot of exploitation taking place, a lot. And people are recognizing that all around the country, that this has to change. So thank you to the drivers, and thank you, Senator Fateh, and advocates, and all of the people who've worked collaboratively on the bill. And Senator Fateh, is there anything you'd like to say before we go ahead and move your bill?
Yeah, thank you so much for hearing this bill today. I'm willing to work with anybody on this committee and outside this committee to make the language in any way you think better. To strengthen the bill, and I appreciate you taking the time today, and I want to thank the drivers as well for coming out, so thank you.
Thank you. Okay.
Madam Chair.
Yes, Senator Pappas.
I'd like to move that Senate File 4780 as amended be recommended to pass and re-referred to the Committee on Commerce.
Commerce. Thank you. On that motion, all in favor say aye. Aye. All opposed say no. The motion passes. Thank you very much. Thank you. Thank you, Senator. Next on our agenda today, we have Senate File 3842, which is a bill brought to us by Senator Housechild.
Yeah, exactly.
David, to your left will be the chief witness.
Okay.
Or you'll
Dave
bring
Bernard,
it up.
of course. So I have, we have
His name on it, it's Department of Health runs that. You're considered an author, it's not ours.
Welcome, Vice Chair Hauschild, to your committee, to your bill.
Thank you, Madam Chair. And before I begin, I do have the A1 author's amendment that was brought by the Department of Health.
Very good. Members, Senator Hauschild moves the adoption of the A1 author's amendment to Senate File 3842. All in favor, please say aye. Aye. Any opposed? The amendment is adopted. Senator, to your bill.
Unsure. Thank you, Madam Chair. Senate File 3842 is a bill regarding well water. Licensed well contractors are in the business of installing water service lines when they construct new and replacement wells. Both the Minnesota Department of Health and Minnesota Department of Labor and Industry have authority over water service lines. Plans for plumbing systems that serve the public, including water service lines, must be submitted to and approved by the Department of Labor and Industry for compliance with the Minnesota Plumbing Code. The Department of Labor and Industry also requires an inspection. Under current Minnesota law, the Department of Labor and Industry may only accept water service line plans designed by the licensed master plumber or engineer. The department cannot accept plans for water service lines designed by licensed well contractors, even though licensed well contractors are allowed to do the installation work for these lines. This bill clarifies that the Department of Labor can accept and review water service line plans that are submitted by licensed well contractors. Today, I have with me excuse me, we already did the amendment, and then I just have two testifiers, Madam Chair.
Thank you. We have David Heinrich and also Bruce Clevin. Welcome to the Senate Labor Committee. And if you would go ahead and introduce yourself for the record and proceed.
Hi, Madam Chair, members of the council. Thank you for having me. I'm David Henrik. I am the president of Burgess Castle Incorporated. We're a water well contractor in Maple Plain, Minnesota. I'm also the chair of the Government Affairs Committee for the Minnesota Water Well Association. And this bill today would help us kind of get out of a gray area that we've been stuck in for a while in terms of being able to submit plans for the work we do. Make no mistake, we've been designing and installing these lines for a very, very long time, as water well contracting in the state goes back over 100 years. And so, you know, this is a good step in the right direction to put us back in an efficient path to get these plans to the Department of Labor and Industry and the Department of Health, so we can make sure that we're getting the proper materials installed and being efficient and getting the work completed as accurately and properly as possible for the customers. So this is really kind of a step that'll help us achieve that very quickly. Thank you.
Thank you for your testimony.
Thank you, Madam Chair. Bruce Clavin for the record. I only have to add that we've met with both departments. Department of Labor does not have concerns. Health, I think, is fine with the amendment going on, and so there's no known opposition.
Thank you. With that, members, are there any questions about the bill today or any discussion? Okay, Senator Dornick.
Thank you, Madam Chair. Thank you, Senator Hauschild, for bringing this forward. Looks good. I like it. So you got an easy one. So thank you for bringing the bill forward.
Thanks, Senator Dornick.
I think you have consensus on that, Senator. Any further questions, any comment? Senator Hauschild, any final comment before we go ahead and lay the bill over?
Sounds good, Madam Chair.
Thank you. All right, with that, Senate File 3842 as amended is laid over for possible inclusion in the omnibus.
Thank you, Madam
Thank
Chair.
you.
Thank you, guys.
I mean, somebody should go up there and present it.
We're just going to take a couple of minutes here while we're waiting for our next bill author. The next bill on our agenda today is Senate File 4202. The lead author of that bill is Senator Mitchell, but Senator Mitchell is needed in a different committee right now, although she's going to try to make her way over here as soon as she can. A co-author of Senate File 4202 is Senator Kupek, who has graciously agreed to stand in for the lead author of the bill so that we can begin receiving some testimony on it today. We do have, well, actually, so if it's okay with you, we do have an author's amendment, Senator Kupek, but I think we'll go ahead and wait for Senator Mitchell to come in case there's anything that she wanted to talk about in regard to that amendment. And we'll just begin receiving the testimony on the bill because we do have a few testifiers who have signed up. So we'll go ahead with that, knowing that we're waiting for Senator Mitchell we'll hope she'll arrive and be able to sort of wrap things up for us. The first testifier we have is Eric Fowler with Fresh Energy. And then we have a series of virtual testifiers, starting with Aaron Sherman. So we'll start with Eric Fowler. If you'd please introduce yourself for the record and proceed with your testimony. Welcome to the committee.
Thanks very much. My name is Eric Fowler. I use he, him, his pronouns. I am on the buildings team at Fresh Energy. Thank you, Madam Chair, and to the committee for the attention on this bill. Fresh Energy is a nonpartisan Minnesota-based clean energy policy nonprofit dedicated to advancing the clean energy economy. And I'm grateful to be testifying in favor of SF 4202 because we need homes that sip rather than guzzle energy. And we need to build them that way from the start. We can build high-performance buildings that can cut up to 80% of energy use with technologies and products that are available today. This bill supports better home building across the state without prescribing one product or fuel type over another. It simply gives the experts at the Department of Labor and Industry an achievable specific goal of 80% energy savings, like the requirement we have for the commercial code. By offering reimbursement for energy rating services, it also supports a growing workforce of energy raters who play a critical role verifying building quality and performance and working with builders on cost-effective energy conservation. We've also appreciated feedback and are in discussion with stakeholders about some continuing work on the language. I'll note, for example, we are supportive of an update. This is not reflected in the A2, but we are supportive of an update, for example, to go from a 2036 target to a 2038 target as requested by some builders. How we survive and thrive in a changing climate starts at home with the home. We have already guaranteed this quality and savings for commercial buildings, and I'm really hopeful that you'll vote yes to give the same quality and performance guarantee to everyone in Minnesota's residential buildings as well.
Thank you for your testimony. Next, we have someone testifying virtually, Aaron Sherman.
Hello and good afternoon.
Yes, we can see you and we can also hear you. If you'd please introduce yourself and proceed with your testimony.
Thank you. My name is Aaron Sherman. I represent RMI, a nonpartisan organization that works to transform global energy systems. I'm grateful to be speaking to you today in support of Senate File 4202. This bill's two parts complement each other. First, it requires Minnesota's energy code for new homes to improve over the next decade so that the state's home will be safe, healthy, and affordable to live in as extreme temperatures and fuel price volatility continue to intensify. Second, it supports the companies that are already building the homes of the future by ensuring they can access the high-efficiency certifications and incentives that their excellent work qualifies for. The proposed rebate program would help build the market for high-efficiency homes and prepare the state workforce to meet and exceed updated energy codes. Excuse me. The energy code portion of the bill would ensure Minnesota homes don't fall behind, as state law already lays out a pathway to improved energy codes for commercial structures and taller apartment buildings. Minnesota residents deserve the same level of protection from climate hazards and energy insecurity. The energy code section would also level the playing field so that all homes would be held to the same performance standard. There would no longer be more lenient requirements for buildings using less efficient appliance types, like gas or propane burning heaters. This provision aligns with the Federal Energy Policy and Conservation Act that allows building energy codes to give credit for measures on a one-to-one equivalent energy use basis. This federal law defines energy use as, quote, the quantity of energy directly consumed by a consumer product at point of use, end quote. In other words, site energy use. Overall, Senate File 4202 is a common sense bill to protect Minnesota residents' well-being and would mean better homes across the state. Thank you.
Thank you for your testimony. Next on our list of testifiers, we have virtual testifier Sam Friesen. Did I pronounce that right?
That's correct.
Okay, make sure to, if you would please make sure to just speak up so that we can hear you clearly. We could hear you, but it's a little bit muffled being remote. So if you would please introduce yourself and proceed with your testimony.
My name is Sam Friesen, and I own Woodworks Homes. We're a design build contractor out of Grand Rapids, Minnesota. And as a designer and builder, I'm acutely aware of the cost benefit of building high efficiency structures. While there are many costly ways to build, we choose to use the cheap options. And as doing so, we're able to meet the goals and requirements of the energy portion of the bill, the 80% reduction. For what we've been seeing is less than 1%. We just did a cost differential on a project at 0.85%. And with that said, the things that we see that increase cost more than these efficiency upgrades would. Just for example, if we go from 1 story to 2 stories for the same square footage, it costs us more money. Extreme weather events have way by out far cost us more money on projects than any efficiency upgrade has. A lot of them increasing as a result of warming. We're also seeing, about 10 years ago, we never needed to put AC in our houses up here. We do need to do that now. That's somewhere on the order of 10 to 12 grand for a really basic AC system in a home now. So the cost, the argument that's based on cost is not realistic. If you choose to use appropriate building systems, we can't simply just turn our 2x6 wall into a high efficiency wall and say, okay, now look, it costs more. There is efficient ways of doing it that save material, they save labor, which benefits us as a general contractor, because that's a huge problem for us. We have major labor shortages. And so there's really good cost benefit on that. As far as the rebate goes, I think it's it's a rural access issue for us. In northern Minnesota, we have no HERS raters right now, and it makes it a real obstacle towards reaching or being able to receive IRA funds that are dependent on that. The cost of bringing them up offsets the benefit enough that it's just not practical to do so. So we'd love to see that. It'll help maybe grow some HERS raters in our region, and I know I'm not alone in that across our area for people that are working in this field. Thank you for your time hearing my testimony today, and have no further statements.
Thank you very much for your testimony. Next, we have someone testifying virtually as well, Kim Kuman. Hello, welcome to the Senate Labor Committee. Oh, I'm sorry, Jim. I'm sorry, I looked at my list wrong. Jim. Welcome to the Senate Labor Committee. We can see you. Can you hear us okay?
I can. Can you hear me?
We can hear you. Just to make sure that you speak slowly enough so that we can make out your words. Sometimes the connection through the internet is a little bit muffled. So just try to speak clearly and a little bit slowly so that we can make sure to hear all your words. But if you'd please introduce yourself and proceed with your testimony.
Thank you, Madam Chair. My name is Jim Kuman. I'm a small business owner, small-scale housing developer, and property owner in the Twin Cities. I focus my business on sustainable housing projects at the 1 to 12 unit scale. And I'm in support of the progressive improvement of our energy codes in subdivision 1G, but I'm going to focus my comments today on section 2, their energy rebate program. I've recently completed a housing project that is an all-electric new construction building striving for net zero energy. And while I personally have a background in architecture construction, it's a bit of a heavy lift, even with my background, to get the details right on a zero energy ready home. And so, because we don't have enough people, even in the Twin Cities, who are knowledgeable of all the details of the design and construction of this work. And since working on this project, I've toured hundreds of people through my project under construction, as well as now upon its opening. And there's incredible interest in how this happened, how do I get this project done? And that's the question, how did you do this? And so that's why I'm in support of today's bills, because we need to increase the number of people who can help get these projects done. And the energy raters are a unique element. For those of you not familiar with what an energy rater is, they are the person who will help in both the review of a design of a project before it's built, as well as the actual in-the-field verification of the construction methodologies used to meet the goals of the certification of things like Energy Star and DOE's Zero Energy Ready Home certifications. And because of the lack of perceived demand, as mentioned by the previous testifier, there are not very many people in the state that are currently been certified to do this work. And so even in the Twin Cities, where there are a few, there's just not enough help to go around. And so in many cases, people are discouraged to even try. And with the tax credits that are available, it's up to $5,000 per unit if it's a building for a 1 to 2 unit building that's zero energy ready certified. That's a huge investment. By making this investment, we can unlock those federal dollars for many homes across the state. And furthermore, by making those costs reimbursable, we can actually get better products. I know in my own building, even when bringing in licensed professionals, people who are somewhat familiar with the technology that we're trying to use, things were still not done correctly. And the verifiers on my project were able to point out the systems and the elements that were not working correctly and make sure they were done right. That's not actually totally required by code. If the thing turns on, the building inspector says yes, even though it's not working to its optimized performance. And so these raters can really provide quality construction and peace of mind to the owners and residents that will live in them thereafter. And so zero energy homes are within our reach today. Even in our cold climate zone, the technology has increased its potential greatly in the last 10 years. And so what we lack right now is the human capital who've been keeping up with that, and to get a little boost in helping those folks and the professionals who are doing this work grow that community. So I support this bill and amendments that are also brewing to make sure that if the reimbursement program does go forward, that the certification reports of the projects that are reimbursed for their ratings are submitted to the state so that we can further understand how our products that are being reaching the certification are doing so, and continue to do research and development on best practices so we can share the word about my products and others that come to fruition under these programs. Thank you for your time today.
Thank you for your testimony. Next, we have another virtual testifier, Michael Carlin.
Hello? Can you hear me?
We can't hear you very
Hello?
well. You're going to have to speak very clearly. Can you try again?
You bet. Can you hear me any better yet?
Yeah, we can hear you okay there. Just make sure that you speak slowly enough, don't get going too quickly, and loudly enough. Thank you for joining the committee today. If you'd introduce yourself and proceed with your testimony.
Absolutely. Thank you so much for your time today. My name is Michael Carlin. I own Fern Custom Carpentry. We're a general contractor located in Duluth, Minnesota. I am speaking in favor of SF 4202 today. The major points for me are some internal and comparative cost studies that we've done with other local builders who build similar similarly to the way that we do, we are generally finding that on single-story structures, we can land within 10% of a code minimum structure with a significant amount of improvement on air sealing and a multitude of other metrics. My second point is discussion on severe weather and the severe weather that we experience quite frequently now in the Twin Ports, with Park Point kind of being a microcosm of that. During the course of my 10-year career, I have worked on a multitude of structures down there that are all code-built structures, and virtually all of them have experienced some level of failure. So from that perspective, the importance of attention to detail, which is part of what this bill addresses, and the attention to improvement of expected performance of the structure are paramount. The third point I'd like to discuss today is the opportunity for jobs, both in the Arrowhead region as well as across northern Minnesota, related to HERS rating and the rebates that would be available to make that that certification or that methodology of tracking metrics much more attainable, achievable, and common in our region. I greatly appreciate your time today. Thank you so much.
Thank you for your testimony. Next, we have Nick Erickson, followed by Jamie Fitzke.
Good afternoon, Madam Chair, members of the committee. My name is Nick Erickson. I'm Senior Director of Housing Policy for Housing First Minnesota. Our members build the communities and places we all call home. Housing First Minnesota also operates the state's largest energy-efficient new construction program, Minnesota's Green Path. We have to date tested and rated more than 40,000 new homes in the state. It's sufficient to say we know a lot about building homes and a lot about building them affordably, but also efficiently. Right now, today, the state's median new home price is roughly $100,000 higher than it is next door in Wisconsin. And to say that cost is a problem, it is. I've been working closely with Senator Mitchell on a lot of her bills, and I'll tell you, she has a dedication to both balancing energy efficiency and also a focus on addressing the state's housing crisis. And as I've shared with her and with other policymakers across the state over the years, we cannot simultaneously move the needle too far on energy efficiency and meet our affordability and inventory metrics. Yeah, we thanked her. We do appreciate the amendment, which we will discuss later. Obviously, she's not here, but the move to a 6-year cycle, that is paramount of importance for both builders and code officials. Also, aligning it to our 6-year code cycle does ensure that the durability analysis, which is paramount for protecting occupant health and structure safety, will be aligned to our building codes. We're very happy to see that. But just looking at the scope of the state's 100,006 unit housing deficit, the gap in our housing costs compared to the rest of the region, we are continuing to work with Senator Mitchell and the companion author in the House to work on a more measured approach. The 80% movement, I got a report on what it will take to get to that point. We are looking at moving our air change rate, which is based on the value of a home. On larger homes, it won't be hard to reach that target, but as we measure homes today, getting smaller, modest starter homes, the ADUs and the other missing middle type of housing that we're working on legalizing here, getting the air change rate to the rates that this bill will require is very hard, because we need homes to breathe. A home does have to leak a little bit. We had a mold crisis about 20, 30 years ago. That was because we didn't understand that homes needed to breathe. So we have to take a measured approach. We continue to work with Senator Mitchell, and if you have any technical questions, happy to answer those. Thank you.
Thank you for your testimony. Next, we have Jamie Fitzke. Welcome to the Labor Committee. If you'd introduce yourself and proceed with your testimony.
Good afternoon, members, Chair McEwen, and members of the Labor Committee. I'm Jamie Fitzke, Director of Government Affairs at CenterPoint Energy. Just wanted to let you know that within your packets contains the director's cut of my testimony here. And what we are seeking is for a sentence to be modified with our proposed language. We have two concerns. One is specifying site energy use. The other is the IECC adoption requirement without Minnesota cold climate protections. And that could be found on lines 3.14 through 3.15 in our suggested language. CenterPoint believes that all Minnesotans should have access to efficient, affordable, and reliable heating, especially during the coldest temperatures. IECC is a U.S.-based membership association that develops model codes for states to adopt on a national level. Our concern is this could ignore Minnesota's unique climate needs by banning critically important heating systems that Minnesotans depend on to heat their homes. And most recently, IECC 2024 process included an amendment to require full electrification of residential new construction, which would have prevented natural gas furnaces. CenterPoint Energy supports homeowners to have access to hybrid heating systems. This is typically when you have an air source heat pump in partnership with a furnace. Air source heat pumps are exceedingly efficient, but their capacity and their efficiency decreases as it gets colder. Independently, it is recommended that an air source heat pump uses an auxiliary system when you get to be 15 to 25 degrees Fahrenheit. So that means it's no longer able to reach the home's heating load. Specifying site energy use for us is a concern because we're not really sure then how that applies to building equipment with varying efficiencies like an air source heat pump. Additionally, site energy use ignores the efficiency losses before the energy reaches the site, and this is counter to accounting methods used by federally recognized DOE, EPA, and Energy Store portfolio. Minnesota-based research and studies have found the most cost-effective and resilient system to heat Minnesota homes is hybrid heating. It provides for the least cost option for home heating. Additionally, it ensures that home heating is available during the coldest weather. To ensure this access is why we are asking for the language to be modified. We hope the author will take our modification into consideration, and thank you for the opportunity to testify.
Thank you for your testimony. And Andy Snope is our final testifier today on this bill. Welcome to the committee. If you'd please introduce yourself and proceed with your testimony.
Thank you, Chair McEwen. Andy Snope I am the Legislative Director for the IBEW. We represent about 5,000 electrical workers locally who work out throughout the state of Minnesota and another 10,000 other locals around the state. Building energy efficiency is what our members and the contractors we work for do. We perform work that helps buildings perform better. Electrification, lighting and load control, building automation, building energy management, process control, and HVAC controls are the tasks that our members perform. We are training to do these tasks, and we continually receive continuing education to update our skills to meet the latest codes and standards adopted by Minnesota Department of Labor and Industry. We support this because it looks like a jobs bill, and it'll put people to work for us, people that we represent. The IBEW is ready to meet that challenge of additional efforts to make homes more energy efficient. We support the efforts outlined in this legislation and have been and will continue to work with Senator Mitchell and all stakeholders to match energy efficiency goals and provide jobs while working within the real-world boundaries of industry and technology advancements towards those end goals. The legislation is a continuation of work to act towards adoption of the most recent nationally adopted efficiency standards while keeping within that framework. I want to thank Senator Mitchell, members of this committee, the Department of Labor and Commerce, and cities and municipalities, all other stakeholders for taking part in the process to help work towards implementation of this bill and the current future energy efficiency standards. We understand that not everyone is completely on board and has some concerns. We would welcome the opportunity to help moderate to get this bill passed and build consensus. Thank you for your time.
Thank you for your testimony. And welcome to the Senate Labor Committee, Senator Mitchell. I know you're really very busy, and I hope it's all right with you that we started proceeding with testimony. We have not taken any votes on your bill, though, and would very much look forward to an introduction of the bill and your thoughts on the bill now, if you're ready.
Thank you. And I appreciate the initiative, because I was presenting a bill somewhere else that had a more robust discussion than we had budgeted time for. So thank you so much for that. So, this is to, I think in the state of Minnesota, we really have a value with being more efficient. And so Senate File 4202 is a residential energy code that will ensure a better climate, indoors and out for all Minnesota. It accelerates efficiency improvements in our state's residential energy code. And some of you might know that, I also have a housing complement because as we try to also correct for the fact that we have 100,000 unit shortage in the state of Minnesota, we need more building just for the people in our state, but we would like to continue to do that in an energy efficient manner. So this is one of our tools to make sure when that new housing is built, it will help maintain comfort and health, but also minimize energy waste, because our emissions, 20% come from our residential housing, and so we just want to continue to improve that number as we continue to improve everything else. So this invests in the buildings of tomorrow with rebate programs, certifications from the U.S. Department of Energy. Qualifying builders can get a federal tax credit. And I don't want to go on too much because I think you heard most of the testimony, and I think it probably covered that. But as I said, I'm a meteorologist, and I come from kind of that wanting to protect our environment background. And so I think this is just one of many steps that we're doing to help do that.
Thank you, Senator Mitchell. And I believe you also have an A2 author's amendment. Would you like us to move forward with the adoption of that amendment so the bill is in the shape that you'd like it to be in?
Yes, please.
Okay. Members, I'll go ahead and move the adoption of the A2 author's amendment on Senate File 4202. All in favor, please say aye. Aye. Any opposed? All right. The A2 amendment is adopted. Members, with that, I'd like to move to any questions or discussions. Yes, Senator Grunhagen.
Oh, thank you, Madam Chair. Yeah, I have an amendment too, but I have a few questions first.
Go ahead. Yep.
In looking at the bill, ranging from 3.4 to 3.17, it looks like, if I'm reading this correctly, we're giving away our local power to legislate to a International Energy Conservation Code department, which is not located in Minnesota. It looks like it's a national or international agency. Why would we do that? Why would we delegate away our power to legislate to an international commission? If you'd like to respond to that, if I'm not understanding it correctly, but that's the way it kind of reads.
Senator Mitchell?
Thank you, Madam Chair. This is something published by the United States Department of Energy, and it would be a baseline, but I think, when we look at our footprint, it is not just a state thing. We need to be kind of good members of the United States, good members of the world, and sometimes there are bodies larger than us that are able to do the research, keep up with the standards, and kind of set those benchmark levels. Because if you look at us as one of 50 states, much like we in the legislature don't all want to be doing the same work on the same thing 60 different ways, and sometimes we would all work together on something. This is something where if the United States is able to do it and help set benchmarks, then each individual state doesn't also have to do that. So that was just a good framework for us to be working off of.
Follow-up, Senator Gruenhagen.
Oh, thank you, Madam Chair. Thanks for that response, Senator Mitchell. You know, another question about that International Energy Conservation. Are they appointed or are they an elected body?
Senator Mitchell, if you know, otherwise, yeah, perhaps we have somebody who does know. Please, could you introduce yourself again for the record, just to make sure we know who's answering?
Thank you, Madam Chair. Thank you, Senator. My name is Eric Fowler with Fresh Energy, and happy to touch on this. The International Code Council is a non-governmental body that collects together a committee of, it's a mixture of building officials, industry representatives, as well as efficiency advocates that work together to create a consensus model code, which is then shared with states. And the federal government does require each state to review the new model code, not necessarily to adopt it, but this is the system that is used for code making in most of the rest of the country, and this is the model code that forms the basis of, for example, the current administrative process is reviewing an update to the residential code, and that is based on the model 2021 International Energy Conservation Code, which does come from the ICC, but is then reviewed for appropriateness by the Department of Labor and Industry, which does not have to adopt it word for word.
Follow-up, Senator Gruenhagen.
Yeah, thank you, Madam Chair. Yeah, thanks for that response. Yeah, see, on line 3.10, it says the commissioner shall adopt residential energy codes from 2025 to 2026 that incrementally move us towards the 80%. So it's like the commissioner in this bill here in the state is told that they must or shall adopt those codes. And I'm very uncomfortable with that. You know, there seems to be a pattern here at the legislature to put some of our local authority in the state to groups outside the state of Minnesota. The one I can just think of right offhand is electric car or car emissions, which now is the California board can tell us what to do. And again, it was an unelected board. And according to your testimony, they're an NGO. NGOs are not elected. And yet we're putting our commissioner and the legislature in a point where they shall adopt those residential energy codes. And to me, that defers our legislative ability based on elected officials to decide what these codes are. So I would greatly encourage you to remove that portion of the bill that's included here and keep our authority locally, if you have a response.
Senator Mitchell or any of the other experts.
Yes, this is Nick Erickson, Housing First Minnesota. So I sit through a lot of building code hearings. The International Code Council, this is the body who creates our model building codes. We already use these codes today. They help build this building. They help build the homes we're building today. These publishers who create these model codes, these are adopted in cities, counties, states across the country. So we're not ceding authority. These still have to go through the rulemaking process within the state of Minnesota, just as when we do our building code updates, which the hardworking men and women at the Department of Labor and Industry who are starting this process now are doing. We rely on these documents so that Minnesota does not need to start from scratch. Every change is heavily scrutinized. It has to go through a number of analysis, technical experts, myself and Mr. Fowler do serve and attend these meetings. I can guarantee you that there's no ceding of authority to outside agencies.
Thank you very much. Follow-up, Senator Gruenhagen.
Oh, thank you. Yeah, thanks for that clarification. And I guess the way it reads, and again, I'm a layperson, not an expert on this, but it does say shall. And I'm not against using outside organizations for information and research, okay? I don't oppose that. but it just seems like we're ceding some of authority with this particular language. Now, maybe I'm not interpreting it correctly, but I would appreciate a little clarification in there. And again, you can use them without putting it into a state statute, in my opinion. Second thing that I'd like to comment on, and I am restricting myself. I have lots of comments, but I'm trying to hold back a little bit.
Thank you.
I believe it was Mr. Erickson that testified that we're $100,000 more for the same house in Wisconsin compared to Minnesota. Is that correct?
Yeah, Nick Erickson again. Yes, that is correct. That's the median price point. Obviously, it's hard to go line by line through every home, but yes, from a median standpoint, that is, and that is one of the reasons Senator Mitchell is working hard, coming from the housing space, to work on helping to knock down those barriers. That is, we do have historically the highest in the region.
Thank you. Senator Grunhagen to the bill.
Yeah, and thank you, Madam Chair. Yeah, and I just want to emphasize that. I have in my hand a printout from the Housing Committee from last year of the average price, median price of a home, and you are absolutely correct. Compared to Wisconsin, according to this information that came from the Housing Committee, to build the same house in Wisconsin is $403,000. To build the same house in Minnesota is $523,000. In North Dakota, it's $425,000. In South Dakota, to build the same house is $350,000. I mean, it's almost $200,000 cheaper. Iowa's $370,000. Even Michigan at $328,000, and Illinois is $381,000. So it seems to me we're an outlier, and I come from an insurance industry background. I own an independent insurance agency. And one of the things that is evaluated when they come up with policies or profit or risk or whatever is what's called return of investment, okay, ROI. In other words, it's evaluated that at this price, are we competitive? Is there a certain amount of profit? And what's the risk we have with that? And when I look at Minnesota, we don't care about ROI. We just keep passing one mandate after the next and driving the cost right through the roof. And the other thing I would caution members is we went through a period of time of huge insulation under the contrived energy shortage under President Carter, where houses were built to not breathe. And I've known people who built some of these houses, and they got mold, they had all types of problems, and some of the materials that were used in there were actually caustic. So they had a hard time selling the house later on. So we seem to be, I hate to use the word blindly, but short-sighted, heading down this path of just higher and higher cost with little or no return on investment in terms of actually affecting the climate. And the easiest way to do that is to compare to the neighboring states, who I would say have the same concerns we do, but they're managing it in a much different way that's more cost-effective for their citizens and helps young couples have an opportunity to own a house.
Senator, those are some pretty broad strokes. I just wanted to focus in on the content of this bill. Do you have an amendment that you would like to offer?
Yeah, I do.
Okay, please proceed.
I was just trying to put my amendment in context.
Understood.
Okay?
Go ahead.
Sometimes you have to set the table. Okay, the amendment I'd like to offer actually is direct, it's the A3 amendment.
Thank you. Senator Grunhagen offers the A3 amendment. While that's being passed out, can you please tell us a little bit about your amendment, Senator?
Yeah, basically, we have a $600,000 grant program to help cover the additional cost that this bill imposes on housing developers or people who are trying to meet that code. And of that, they say $100,000 is administration. Well, if you divide 100,000 by 600,000, we come up with a figure of almost 17% administrative costs. Now, I've been around here at the House, and this is the first couple years in the Senate, but when we've looked at administration costs on the total amount of bills, that I've looked at over the years, the administrative costs are usually between 2 and 5%. They're never at, over 10% that I can remember, and this one goes even almost to 17%. And yet the intent of this money is to try to help to cover the cost, the higher cost that this bill imposes on the construction of residential homes. So members, I think what this amendment does, it reduces the administrative cost from $100,000 down to 5% of the total, which would be $30,000. I think that's a much more reasonable percentage to work with than the almost 17% of the money that's supposed to be used to help cover the higher cost, rather than putting it into administration, putting it into the actual subsidies.
Okay.
So, member, I would encourage a yes vote.
Thank you, Senator. Senator Mitchell, would you like to speak to the proposed amendment?
Yes, thank you. I would encourage a no vote. One, this was not brought to me beforehand, and I like to actually have conversations about these issues. But two, if you actually read the language of 5.7, it says for administration and outreach and technical assistance to applicants. So this is also to, and it's up to, so it doesn't require that 100,000 be used, but if while getting the word out and especially making sure our Minnesotans are able to access this, that we need a little extra money, then it is here and available if that is needed, but it is not just administration.
Thank you, Senator. All right. Senator Grunhagen has moved the adoption of the A3 amendment to Senate file, make sure I have my number right, 4202. All in favor of adopting the amendment, please say aye.
Aye.
All opposed, please say no or nay. No, the amendment does not pass. Members, further discussion or any other further amendments? Senator Dornick.
Thank you, Madam Chair. Thank you, Senator Mitchell, for this bill. I definitely support the concept, and I know that we've made great strides in Minnesota, and we have been the leader for years. As we look in, I remodel old houses sometimes, and there's no insulation, or there's newspaper, or whatever. So in 2015, I believe, is when we passed the last big energy code, and we made a big jump there. And the concern I have is with the price of homes. And as you mentioned, I think it was 100,000 units short. I think that's what you said. So that's my concern is we're trying to do a good thing here, but will it cost and harm these lower, mid to lower income people that want to build a house? I know that's one of the most thrilling things to do as a builder, to build a house for somebody that, that's so exciting. It's such an exciting time to have that thrill of building a house and for them experiencing that of a new home. And I'm just afraid that we're pushing that away from them, some of these, because it's so difficult with the price. And I know the intention here is nothing but good, but I'm just concerned with the prices. And people are on budgets, and I know when I built my house, I chose to do more insulation because I looked at the cost, and how long it would take to pay back, and then I had a budget I had to work with. And so I think we're pushing that budgeting away, and that opportunity to build a house, I think, is getting out of reach for many. And I talked to one of my local builder friends in Rochester this morning and just asked him about this bill and some other bills that we were hearing, because he's an expert and he's in that. And so they need 900 houses a year in Rochester, 900. And he said they're building about 200. And the ones they're building are 6, 7, 800,000 house. It's for the people that have more money than many do. And so that's my concern. Not that I don't like the bill, I just don't like the unintended consequences that I see, that it's going to put the housing out of reach. And not only that, but as we increase costs for housing, it does push rental prices up, and we're having such a squeeze there on renters. So there's one letter that, there's many, and I try to read all of them. Sometimes it's hard to, but that I thought he did a really good job. Mr. Boyd talked about the adverse effect on renters and lower points and make missing middle and new starter homes unaffordable. And then he finishes, energy efficiency is important for Minnesota. Absolutely it is, but so is being affordable. So with this balance, we have to be careful that we're not making this out of reach. And I think that's what this bill does in its current form. I think the push for commercial last year, I'd like to hear how that's going, how the cost of that, and some data on that before we move to the residential market. So again, thank you for your bill. Thank you for the testifiers. And I look forward to hearing more and maybe navigating through this so we can make it so it's not that dream of owning a house is a new one for many that would like to. Thank you, Madam Chair.
Thank you, Senator. Senator Gruenhagen, you have 1 minute.
Do you have a stopwatch? No,
I do.
Oh, thank you, Madam Chair. Yeah, just a real quick concern too. I won't elaborate on it, but I did do a little bit of checking on the cost of an electric furnace, and it's about $14,000. And then we're pushing towards electrical, and at the same time we're undermining the grid with solar and wind, which isn't base load. And I just don't think it's a good formula going forward. And we've already had testimony and reports in the media of the potential of rolling blackouts here in the state. So again, this bill pushes construction in a direction that I think is going to have serious consequences, and I'd strongly encourage you to modify that. Thank you, Madam Chair.
Thank you, Senator. I don't see any further discussion. I have some comments as well. I just wanted to thank all of the testifiers who came to testify about this bill. I know that I had a number of testifiers, builders and professionals from northern Minnesota and from Duluth in particular, and want to shout out their efforts and the work that they do. I also, it is my understanding, and what I read in this bill is to try to bring the costs down for some of these amazing innovations, and really to try and provide a little helping hand to get us where we know that we need to go. And we're sort of late to the game. So I really very much appreciate, Senator Mitchell, you bringing this bill, and appreciate all the advocates for bringing it forward. And with that, I'll turn it over to you, Senator, for any last comments. I believe that we are going, the path for this bill is to be re-referred to state and local government next after this. But before we move your bill, if you have any final words.
I had on my notes energy. I could be wrong.
No, that's correct. I think that's correct. Is it energy instead, or is it state and local government? We are double checking.
Thank you. But in the meantime, if I may, I definitely appreciate the comments. As the chair said, we also have some pieces working on adding housing in Minnesota, and some of the provisions in that are things that will not only create more, but do it in a more affordable way. So we are working on that piece too. But I think we definitely have a balance of wanting to secure clean air and clean water and be mindful of our environment as we do things for our future generations, as we do what we are doing. I would also just like to say, I had the chance to tour some incredible, like, best practices built townhomes that were in Northfield last fall. And when they built to the highest standards, which did increase costs somewhat, but as they built more of them, the costs went down so that it wasn't much of an uptick once they'd kind of gotten that formula down. And they were paying, I kid you not, less than $300 a year in energy costs.
Yes.
And that is savings to our families. So we can both be mindful of how we do our housing, do it in a more affordable way, do it in an environmental way. We can try and do all the things, and we are honestly working on all the things. Thank you.
Thank you very much, Senator. Senator Pappas.
Can I move the bill?
Yes, please.
Thank you,
And it
Madam
is going to
Chair.
energy.
I move that Senate File 4202 be amended, be recommended to pass, and re-referred to the Committee on Energy.
Thank you, Senator Pappas. On that motion, all in favor say aye. Aye. Any opposed, say no. No. The motion passes. Thank you very much, Senator Mitchell. Members, as we all know by looking at the clock, we've been running over trying to fit all of these bills in, but we will need to recess. We do still have 2 bills on the agenda, and I believe that what we are going to do is recess and reconvene at 5:30? Okay. We anticipate it'll be 5 or 5:30, but members and people can keep a look on their emails. It will confirm what time we're going to reconvene. Thank you, everyone. See you soon.